Good afternoon or good morning to everyone in attendance for this webinar, regardless of which coast you're on. We're really thrilled that you were able to join us for today's webinar, Common Compliance Challenges, and we're looking specifically at the intersection of the Clery Act and Title IX when it comes to campus security authorities and responsible employees. This webinar is a series of free webinars during National Campus Safety Awareness Month. My name is Allison Kiss. I'm one of the presenters today, and I will also moderate today's webinar with my colleague Amy Guthrie, who will be available through the chat box or questions box. It's the same box for you. If you have any technical difficulties or questions, you can certainly send a note to Amy. I want to go through some housekeeping items before we start. I'm going to encourage you again to interact with us by putting some questions and comments in the question pane. We may not have time to answer all of those, but they may also help us to inform some of the content for today or to know where some of you are having challenges. We will also record today's webinar and we'll make it available for you as needed. If you had not yet had the opportunity to sign up and participate in this year's National Campus Safety Awareness Month campaign, you can do so by clicking the link in the control panel. It has information, Know More, Do More, which is filled with free professional development for your campus on a number of different topics. And so today, to give you a sense of the flow of today's webinar, I'm going to start with the panelist discussion, and if time permits, we will have some questions at the end. But we do have a lot of information to get to in an hour, so if you have any follow-up questions or information that you need, you can certainly reach out to us out at the Clery Center. I do want to point out in the handouts section of your webinar, there's the Common Compliance Challenges, a PDF of the slides, and then a link for a training held at Springfield College in Springfield, Massachusetts that will certainly delve a lot deeper into Title IX and will highlight kind of some of the challenges with investigations and things of that nature, and that is sponsored by our friends at the Victim Rights Law Center. I'm really thrilled to be joined by my colleague, Lindy Aldridge from the Victim Rights Law Center. We have presented in person on the intersections of the Clery Act and Title IX now at several locations throughout the country. I know that when I have a question about Title IX, it certainly intersects with Clery, and I know some information about it, but I often will defer to my colleagues, the attorneys at the Victim Rights Law Centers. They're on the ground doing this work. They have a tremendous amount of information, and I'm always mesmerized when I listen to Lindy talk about this because the work that they do is real. It's based on practical examples, and so many times they'll bring in hypotheticals that are pulled from things that are happening on campuses, and that can really help us to understand better what some of the challenges are. There's copyright information on the main slide, and then also from Victims' Rights Law Center. If there's information that you would like more, you wanted to cite in some way or something of that nature, please contact Lindy at Victim Rights Law Center, or you can contact us at the Clery Center for our information. But I'm going to pass it over to Lindy as we start, because a main theme of this is when you get a student who discloses or reports something, and it's certainly important to know the difference. So I'm going to pitch it to Lindy to start.
Hi, everybody. Thanks so much for spending this hour with us. I know you guys are all really busy. It's been one of the things I've learned over the last 6 or 7 years of training. It's just kind of how humbled I am to learn about how many different hats you wear and how many things you have on your plates. So I really respect and thank you for spending an hour with us to learn more about this. So thank you. Again, my name is Lindy Aldridge. I'm the Deputy Director at the Victim Rights Law Center. I'm out of our Boston office, where we provide direct legal services only to victims of rape and sexual assault. We have several grants from the Office of Violence Against Women, and we take what we learn in our cases and then we go out and we train nationally. And that's what I've been doing around Title IX, which is my area of specialty. I've been doing that for the last 6 years with OVW and also with colleagues like the Clery Center and Allison and a variety of other institutions that are doing really great work as well as what Allison's doing. So let's jump in. Just knowing today, we kind of put a bunch of things together, but more information is coming out about this stuff, we're actually working on some materials with the Office of Violence Against Women around confidentiality, and hopefully those will be released hopefully mid-fall. So be on the lookout for those. They're going to be free, and they're going to be offered on changingourcampus.org, which also has some of the materials that we've done with them. So keep a lookout for some of the stuff we're going to be talking about. So as Allison mentioned in the disclosing and reporting slide, this is really at the crux of what the VRLC believes is how victims tell or share their experiences. And I think for many, when we think about kind of, you know, the kind of campus sexual assault movement that's been happening in the media and with student activists and, you know, kind of this kind of epic thing that's going on right now in the country, I think a lot of times most of the attention is spent on once the victim hits your door. There isn't a ton of time spent on what happens prior to them getting to your door. And I truly think it is that mechanism, that understanding of how once you have some kind of event or incident that occurs and what some of the corresponding trauma or other kind of crisis pieces are that lead victims to either want to kind of hang back in the shadows or to potentially come forward. And the reason we have this distinction is that there are many, many victims, and for those of you who work with victims often, I think you understand there is this distinction that many, many victims come forward, and they come forward because they have reached some kind of crisis bottom, and they are either going to fail out, they are cutting or suicidal, they are having some kind of bigger issue that they can no longer kind of continue to hide from, and they're reaching out for help. Now, there are certainly victims who come forward who wish to report. They certainly wish to go to law enforcement, or they wish to file, you know, a conduct complaint. But I think the vast majority of victims, and I think statistics would bear this out, the vast majority of victims are really, if they come forward, they're looking to get immediate crisis services. They're looking to kind of fix their class schedule, receive therapy or counseling, maybe get some medical services. They may be looking for a medical leave or withdrawal. They're not necessarily ready at that point to engage in a full report process. So I think it's an important piece to kind of understand that that's really at the crux of the work that I do, is that there is this distinction. Now, Department of Education does not make this distinction. This is a purely Lindy Aldrich distinction here in terms of based on my experiences, you know, in the courtroom and with our clients. It is important to note that you won't find the word disclosure in any of the Department of Education materials, but I don't think it makes it any less real. And I think it's an important piece to kind of consider as you start to create your response protocols on your campus. So when we think about intersectionality, I think the first thing we need to think about is kind of what's out there about responsible employees. And the Department of Education has given these three definitions. And I'll be honest with you, I don't find them particularly helpful. I think, frankly, they're meant for K through 12. I think that's kind of where they were headed when they drafted these. So in some ways, I wanted you to have them. But I would think that actually it might be a bigger help as we kind of look into other guidance to kind of think more about what to do with them. But I at least wanted you to have those definitions. When we think about kind of where responsible employees fit into the greater structure, if you looked at the most recent Q&A, they came out with 3 buckets. And those 3 buckets, and go ahead, Allison, if you want to put that forward. There are kind of 3 different areas that employees at a higher education institution could fall into. They could fall into persons who have statutory privilege. You could deem a particular employee as having confidentiality. And you can also deem employees to be responsible. Now, I do a full presentation that can go on for hours on, frankly, all 3 of these buckets. But I will say this. If you are currently at an institution who does not have any confidential persons, I would really think strongly about creating them. As I mentioned before in that disclosure versus reporting phenomenon, I think if folks who have been in a domestic violence, a stalking, or a sexual violence incident do not have a place to go where they can kind of sort out and prioritize what's going on with them, be it mental health, could be physical health, and also just kind of logistics of work study and, you know, their grades and tuition and costs and all. If they don't have a place to go to kind of sort out those kind of immediate crisis issues, I find that in our work, the clients who don't have that often will not proceed down any accountability avenue. So I think it's important to consider, for those of you who don't have one, the importance of the potential of creating one. Now, those schools who do have employees that have statutory privilege, which could be people, this is very state specific, but they could be, you know, folks who are in your, if you have a counseling center, if you have a health center. I know for community colleges that's not necessarily very common. Or you may have folks on campus. Some larger schools have folks who have actually legal services on campus. There are a variety of different places, social workers. Many states have advocate privilege. So if you have a women's center and advocates have privilege, that might also make a difference. So it's important to make sure that you've done some kind of audit on your campus to ensure that the folks who actually have privilege and are working in that capacity at the time that they would receive some kind of disclosure are identified and communicated out to your students. You may also consider whether or not you want to deem other folks as confidential. One big piece of the confidentiality is that they have to provide aggregate data. Privileged folks do not have to provide aggregate data because their privilege prevents them from providing details. Now, you can, as a privileged person, provide aggregate data, but it's a voluntary basis, and it should never have any personally identifying information, as the same is for the persons with confidentiality. That's another intersection with Clery we may or may not get to today, but I wanted to bring it up because it's a big piece. And those materials that I mentioned earlier with the Office of Violence Against Women that are coming out this fall will go into great depth as to those intersectionality. Responsible employees, that is really kind of who else do you have on campus and how do you wish to deem them? Some schools are using faculty, some schools aren't. Some schools are using some faculty and some aren't. Some are using all administrators, there's coaches, there's all kinds of different pieces. And obviously, as we're saying these, there is some overlap with CSAs, which we're going to continue to kind of keep thinking about. So there's a lot of choices here, and I really strongly encourage you to really map this out. Do an audit of all the different employees you have, figure out which of these 3 buckets, or if you're only going to have 2 buckets, where are they going to sit, where are they going to live. And then the other big piece here is once you figure out who's going to sit in those buckets, you need to communicate that out to your students. You knowing what your employees are does no good. Your students, your community has to understand what buckets your employees live in. Coming up with simple visual ways to explain who's what and what their obligations are is a huge piece that I think is missing in the conversation around explaining how victims are asking victims to reach out for help and in what ways. So I think, don't forget that. Oftentimes people treat it as an afterthought, but it's actually probably the biggest part of the entire process, is making sure that once you've made those decisions, that you're communicating those decisions. So let's talk about responsible employees and what they have to tell students. So if you've named your responsible employees, you've told who those people are going to be, and you've explained it to students. If a student gets to that responsible employee, there are 3 things that should happen at that point. So what has to happen is, number 1, the responsible employee needs to alert the student that they are going to have to report relevant details. And once they report those, then who they're going to report them to, which is generally the Title IX coordinator, but I could obviously see where it may not be. For instance, a resident advisor may have to tell a resident director. So being able and being clear to tell what I'm going to tell them and who. The other thing is they have to offer the student the option to request confidentiality. And that just means that even though perhaps the student who went to this faculty member not knowing that they were going to have to report this information, now they would have kind of another chance at confidentiality, which has to then go to the Title IX coordinator for an assessment. We're going to talk about that in just a second. And then lastly, they need to share with them information about where they can access confidential resources, as well as, advocacy, health, mental health, all these different pieces that they can access. And that's also going to be a Clery requirement that Allison's going to talk about. So speaking of that safety risk analysis, this was a huge piece. So you can go forward, Allison. The balancing test, especially coming out of the Dear Colleague letter from 2011, where we had the must promptly investigate. That year in 2012, well, really up until 2014 when they issued the Q&A, was really a difficult time because everyone kept kind of throwing at me, well, must promptly investigate, you have to investigate. And I think what they did well in the Q&A that came out, and this is a direct quote, is they kind of walked a little backwards from that must promptly investigate. And what they did is they said, when you're weighing a student's request for confidentiality, so that's that, you know, you can tell the student that, hey, I know you didn't think that I was going to have to report this. I do, but I'm going to pass along to the Title IX coordinator that you've asked for confidentiality. You didn't intend to report, but it happened anyway. Cat's out of the bag. So when you're weighing that student's request for confidentiality, that could preclude a meaningful investigation. So there's that little kind of back off of must promptly, right? It could preclude an investigation or potential discipline. A school should consider a range of factors. So it's an important sentence. It's in the Q&A from 2014. So let's talk a little bit about what those factors are. And there's a list of them. Back in 2001, when that guidance came out, the original guidance in 2001, around these issues, there were only really 3 factors. So the Q&A in 2014 really beefed that up. It really talked a lot more about what schools could consider. So just know a couple of things. One, these factors were created thinking about kind of the community at large. If you look at some of the language, it talks about kind of talking about the greater community. So one of the biggest things I get questions I get about the safety risk factors is, what do I do in a domestic violence situation or a stalking situation where we're really talking about the safety of one person? I feel strongly that that was not what was intended. I don't think we're going to get any additional guidance from the Department of Education on that. But if you look at that language, I think they're saying for sexual violence or for other crimes that would impact the greater community as a whole, these factors were meant to be considered in terms of assessing your community's safety. These factors, a whole bunch of them, they talk about, you know, have you ever heard of sexual violence complaints about this accused student? Have there been a history of arrest? Did they threaten additional sexual violence or other violence? Were there multiple perpetrators? That one about increased risk of future acts. So what that is essentially saying, do you have a property off campus where you've had multiple acts of violence coming from the same house? Is there a place where there's a bunch of off-campus parties, or is there a place that has like a gym or a meet, or is there something, you know, that's happening off campus where there seems to be a pattern of violence? Was there a weapon? The age of the student, because again we're talking about K through 12, and whether or not they have means to possess other relevant evidence. So these are things like surveillance video, or if somebody has a phone or things like that. The only small thing I will say about that last little, you know, piece around other relevant evidence, be careful what you go looking for. If you have someone sitting in front of you with the video on their phone, feel free to take a look at it and be on notice. But I caution you against kind of Googling things and going to look for other evidence. It is my belief that that is not what they intended, and that the intention was that you're on notice with what's kind of in front of you. And if there is, you know, evidence that's easy for you to obtain, your own surveillance, you know, things that were shot by an employee or things like that, that's different than you Googling a name and coming up with things you didn't have before. So this is really kind of in a nutshell, in a very small nutshell, around confidential protocols and what happens when a responsible employee learns of a report, or frankly a disclosure potentially, and what can be done. So I'm going to flip it at this point over to Allison, and she's going to talk a little bit about setting up what this Campus Security Authority does.
Thank you so much, Lindy. So we're going to talk a little bit now about what a Campus Security Authority is. And, you know, like Lindy, we have talked for many years when we train campuses on campus security authorities, and to be quite honest, it's one of the common compliance challenges we see in Department of Education reports and that we have seen in reports. Probably most notably in the news around 2011, the news of the Penn State case and the Clery investigation that's going on there that largely looked at people who were campus security authorities. And then kind of the next step from there, we also have made that distinction for a long time when we talk about campus security authorities. When you're getting a report of a stolen vehicle, or you're getting a report of a robbery, it's very clear you're getting a report as a campus security authority, and that you want to take that information. You're obligated, or sometimes people call people who are CSAs mandated reporters, but you're obligated to get that to public safety. Where the challenge comes in, and what we've seen over the years, and it's why we've created a pretty comprehensive training video on this, is that when a campus security authority gets a disclosure or a student talks to a campus security authority because of their rapport with that person, that's where we see the challenge, because often people who are acting in the capacity as campus security authorities feel like they may be violating the trust of that student. And this especially comes into place when we're talking about students who fill in a role as campus security authorities. So this visual here that you are welcome to use, and I think that anytime you can create some sort of infograph, Lindy did a great job talking about ways you want to communicate to your campus where they can go for assistance. And so we kind of created this piece because we thought it was important to point out the different times that someone might be a campus security authority. So there's, you have officials with significant responsibility for student and campus activities. This is going to be your most common campus or your largest group of campus security authorities outside campus public safety. This is typically anyone who has a role in student life, in student affairs, in student activities, in athletics. It's not going to count those who have privilege, so your pastoral or professional counseling. But it's basically someone who is a director of Greek life, an assistant director of Greek life, an advisor to a club. It could be a coach or a club sport coach. The obvious is a campus police or security officer. It also can be individual offices designated to receive crime reports. And I know that we have some folks on our call who come from smaller institutions, potentially a beauty school, a trade school, where you have a new crop of students every 6 weeks or every 12 weeks. You may not have a full police department, so you may have other offices that you're designating students to go to report crimes. That makes them campus security authorities. And then individuals who have responsibility for campus security. So if you have someone who's monitoring a residence hall, checking IDs, checking people in and out, signing guests in and out, they serve in this role. And we also included on the right in the column there some examples of campus security authorities. And there's no one size fits all. The law gives you these boxes that you put people in, but again, it goes to your campus and determining who fits these roles. So typically you have resident assistants when we're talking about students. If your RAs are students, they fall in that role. Coaches, student activity staff, faculty or staff advisors to student groups. So what's the goal of a campus security authority? So they have to report to an official or an office designated by the institution any allegations that are Clery crimes that they believe were made in good faith. So if a CSA gets a report of a sexual assault, and maybe it's a roommate saying she believes her roommate was sexually assaulted, that's something that's considered in good faith. So you want to get that information where it needs to go with public safety. Now we know it's not that easy. We know that there can be challenges when you're doing this. If a student is reporting and they want to protect their confidentiality in some way, if a student is reporting and they don't want to go through the law enforcement process, these are some of the challenges that come up. So it's really important to communicate what a campus security authority is, what the role of a campus security authority is, and what they do when they get the information, and how to communicate with that student if you do have to bring it to a public safety office. How do you explain why? And it's a great exercise. We do quite a bit of trainings throughout the country. And one of the best exercises we do with RAs is, one, get them to understand what the act is about, that it's not just about numbers, but it's about making sure services are available for people. But also, you know, making sure that they can communicate why they have to go forward. And sometimes that means saying, I'm not qualified to best respond to you, and I care about you, and I'll go with you when we move forward with this. A campus security authority is not responsible for determining whether a crime took place. And sometimes people think that's silly when we say CSAs should not investigate. But there are many cases where you may have we've seen the director of Greek life trying to mediate a case, or two coaches. If you have a men's baseball team, women's softball team, and the two coaches are trying to work out the situation. We certainly don't want to do that. It can certainly raise concerns about Title IX, but it's important to know kind of what the role is. A campus security authority will report the Clery crimes, and we have them listed on this slide. If you don't know, I think when you're training your campus security authorities, they may not know what all the Clery crimes are. You can certainly provide them with a handout of them. But I think it's a good practice, too, to report any crime, and campus law enforcement or public safety can determine if it falls into the Clery pieces, as well as provide services for all victims of crime, not just Clery crimes. There have been changes to the Clery Act that include dating violence, domestic violence, and stalking. So now we know that those crimes based on the VAWA amendments to the Clery Act are considered or are part of the reporting process. So why do I need to report? That's one of the common questions. One reason is stats. The other reasons are for ongoing disclosures. So there may be time where a timely warning has to go out to your community. Only, it's not mandated in all cases of sexual assault, but it is mandated that every case that happens that's a Clery crime in specific geography has to be evaluated. You may not issue a timely warning because it might put at risk the victim. It might identify that person. There may no longer be a threat, but it's something that has to be weighed and considered. So if your Title IX coordinator and your Clery coordinator or your person who's handling Clery are not interacting, they should. They should be communicating regularly about what their process is and how that information gets out, because a Title IX coordinator is also a campus security authority. So there are different ongoing disclosures as part of Clery, and I bring them up now and their relevance to campus security authorities because this is one of the reasons a CSA has to pass along information. They have to determine if a campus needs to issue an emergency notification. And that basically was an amendment to the Clery Act in 2008. It was sparked by the loss of 32 lives at Virginia Tech. And the purpose is to notify the public, and it's broader than just Clery crimes, but if there's any kind of immediate threat to campus. Timely warnings have a narrower focus on Clery crimes. They reach the entire community, and it's issued when there is a current or ongoing threat to campus safety. So I'll say that again, a current or ongoing threat to campus safety. It's a need to know for safety, not a need to know to simply be in the know, which I think is an important distinction. And then there's a public crime log, which is something that's made available to the community when there is crime that has occurred. So there are times or circumstances that trigger warnings. It can be a Clery Act crime or a report to a CSA. It's in a specific geographic area, and as I mentioned, it represents a threat. So I am going to now Lindy and I will interact a little bit because I think we need to understand, and some of this kind of was pulled, I think the White House Task Force did a good job of looking at the differences of Clery and Title IX. I think that they certainly intersect and they do not contradict one another, but
So I think what we make sure, and you'll notice here it says the dear colleague letter from 2011 says must promptly investigate upon notice of a possible sexual assault, which also includes deviant stalking or any kind of gender-based misconduct. So I think for Title IX purposes, and I think this is an important distinction, is to realize that Title IX is a civil rights bill. You know, it's legislation that was intended to provide civil rights around anti-discrimination in our public schools and any school that receives federal funding. So I think in Title IX's eyes is that, you know, a school has to take action once they find out or receive, you know, this report. And that's why I make that distinction between report and disclosure. And when that happens, they're expected to investigate that report. And I think in some ways that term can also mean respond. It does not necessarily mean you have to proceed immediately with a full investigation. What I think it also can mean is taking a look at the circumstances similar to those factors and making a decision if the victim asks not to proceed. So in a nutshell, that's kind of like what happens once they receive that report.
And then in terms of Clery, you know, a Clery crime occurs on your geography. It's reported to a CSA, and it's considered to represent a current or ongoing threat. So if you have something that there is a current or ongoing threat to your campus, then a timely warning may have to be issued. And typically when a timely warning is issued, you don't want to have information in there. And unfortunately, it's a trend I've seen lately where they'll have information that will say the victim chose not to move forward with a complaint. And I really would kind of caution you to think about what's the purpose of the information. It's to promote safety. So the information or the decision of the victim, should that be issued in the complaint? You want to make sure you withhold any kind of identifiable information. And sometimes listing a residence hall, depending on the size of your campus, may identify that survivor.
And then this time we're talking about that balancing test. So when you receive a report and the victim asks for confidentiality, under Title IX, you can actually kind of weigh whether or not you're going to proceed by using those, I think there are 9 factors, and determine whether or not you have enough to move forward, and generally means without the victim, or in spite of the victim to some extent, because the victim can choose at any point to not participate, and I think you're really kind of finding the worst of the worst cases where you feel like you have to proceed because you have a greater campus security threat, and so you feel that you have to proceed with some kind of investigation or conduct, resolution process in order to maintain safety.
And then with Clery, again, when to issue a timely warning, again, it's based on a determination or a serious or continuing threat. So this is why there's a case-by-case basis. And the handbook for campus for Clery reporting in 2011, which is in the process of being updated. I think we initially were supposed to get a new version July, and they pushed it back a little bit, but hopefully we will have it in the next couple of months that will give you some kind of real answers or solutions to how to determine through hypotheticals how to determine whether to issue a warning. So we put together a hypothetical, and we've used these in in-person trainings. And Lindy, if we go through these, I can ask people to type in the chat box some of their thoughts and share them with the group so we know what we're doing. So I'm going to start. We have, in this case, and these cases are taken, and I believe most of the hypos we're using today are from Lindy's direct experiences, so I appreciate her in sharing these with us because I think they kind of paint pictures of what we're seeing on campuses. So Lindy, do you want to kind of give the broad overview, or should we just have people read them?
Yeah, I'm happy to run them through. So in this one, we have Maria, who's introduced to Derek at an off-campus party by another girl in their class. And for the purposes of this, I think we're going to say off-campus is something that is controlled by Clery, I believe is where we've made, just so that you guys understand. Yeah. Initially, she really enjoys hanging out. They drink for several hours. Because of all the drinking, her memory of the rape is really blurred by alcohol, but she has numerous cuts and bruises on the back of her head and her back. She feels that she may have been dragged by the hair at one point. During the conversation earlier in the night, Derek made several joking references to keeping guns in his dorm room. Maria didn't take him seriously at the time. She believes that Derek had no weapons on him at the time of the rape, but she's afraid that he may have told her those stories earlier that night for a reason. So we wanted to take that hypo and really kind of breaking it down via kind of Title IX and Clery, and to think through not only, we're going to give you a little information in just a second about who Maria discloses to, because that's a big deal. But I think you want to think about number one is if Maria comes forward and asks for confidentiality, what happens? How do you determine, based on the factored list, whether or not it relieves the obligation of the school to proceed with an investigation? And then secondly, what about that obligation to send a timely warning?
So if you all want to take some time to think about those, you can type some quick thoughts in the chat box, and I won't identify people by name, but I'll share some of the things that are coming in. So if you want to talk about what if someone requests, what if she requests confidentiality, does it relieve an institution's obligation to investigate? So let's start with that piece. Let's say she says, I want confidentiality. Maria says this. Does an institution have to investigate? And I'd love you to just kind of enter in the chat box some of your thoughts. You can say yes, no. Go ahead.
Yeah, and I think as you're thinking about it, think through those factors that we talked about, because that's what the analysis would really be, is to assess about that hypo, what parts of it would or would not meet those factored questions. And I'll be honest with you, at your institution, you may have additional factors that you would consider. You know, I've had several faith-based institutions or dry campuses, you know, where the alcohol use at all would be a factor in terms of whether or not they would proceed. So again, you know, you may have different questions you would ask, but at least those factors are a place to start.
And some of the responses we're getting, I believe that the school must still investigate. She has the right not to report to law enforcement, but they still must investigate. We have some yeses and some nos, kind of equally. SPED cannot promise confidentiality when the information is passed to a campus security authority, and Title IX pass along that the victim would like confidentiality. The crime log will allow the redaction of the identifiable information. Someone says safety concerns about the possible guns. Someone asked about Clery geography, and we are saying this is a fraternity house that is owned and controlled. School must investigate, does not relieve the school from investigation. Yes, investigation. The school does have to investigate the guns. Yeah. So Lindy, I'll let you go. And we do have a mix of yes and no's. We have a lot of really good feedback in here, but the majority are saying yes, we should investigate, but some are saying no. So I'll pitch to you, Lindy.
And I think I would likely agree with you on this case. Number one, the guns make me quite concerned, even though he didn't have a weapon on him at the time, or she doesn't believe he did. The fact that he had weapons or potentially had weapons in his residence makes me deeply concerned. Also, the cuts and bruises on the back of the hair, the potential of the dragging might also be something that would kind of pop for me in terms of my factors, that there was not only the violence of the rape, but the potential that there was also a lot of physical violence as well. So for those of you who are saying yes, this would be a yes for me, that even if she asked for confidentiality, I would have some deep concerns that this posed a greater risk to the entire campus. So for me, this would be alerting the victim that although you've asked for confidentiality due to other factors that we know about, we're going to proceed.
And so then the next question is, and I'll let you all take time to type this, what about a timely warning? Does this relieve an obligation to send a timely warning? If she wants some sort of confidentiality, may not want to move forward, what about a timely warning? And again, I want to clarify, there's no right or wrong answer. You're doing exactly this when you get cases in. You're evaluating for whether or not you need to issue a timely warning with the information. And you can always tell when we have some law enforcement on or investigators on our webinars, because they'll often say, I need more information. So remember, this is a hypothetical. So let's say this is all of the information you have. How would you evaluate it? What would you consider? So take some time to type that in. And so we are again divided here. Some people are saying no timely warning because there's no clear evidence of guns. Somebody else says, I think a timely warning is necessary because another person may be a victim. It is a potential threat to the community until we know that there are no guns. Someone wrote in here, I would write something about potential of guns in a room. Somebody did write and say, I couldn't determine, but my next step to make a determination is going to be to potentially search the room. And again, I think that depends on your Office of Residence Life, sometimes public or private institution, you know, what kind of basis you need to search the room. Great. Someone said, and this is really, I think, insightful, because this is a fraternity and a number of students socialize there, we would believe a timely warning is needed because of concern. Great. Okay. These are great. So now the next piece we want to talk about who Mary may disclose to and what their obligations are based on that disclosure. And do you think, Lindy, should we go through these one by one, or do you want to pick out certain pieces?
I think it may depend, too, on the institutions we have on the phone, too, because Both Allison and I have been doing quite a bit of different work also with community colleges, and I think they have some different requirements, and that they may have to really think through things. So maybe let's go one by one, just kind of depend, just so that we can pick out the community college differences.
So we'll start with a resident advisor. In terms of a resident advisor, in the case of a campus security authority, a resident advisor is a campus security authority. So, they would have the obligation then, and it depends on your institution of whether or not they go to their direct supervisor who reports the information, or whether they go, what your protocol is, or whether they go directly to public safety to do that. So that would be their CSA obligation.
And then under Title IX, if they're responsible employees, they would be required to either go to the next link in the chain. Either they'd have to go up to their residence director, or they could go straight to the Title IX office.
Something that we've seen institutions doing to streamline the process a little more is if you have people who are both responsible employees and CSAs, which many are, once they go to the Title IX coordinator, that person is a CSA. So just not to duplicate efforts, that's another kind of streamlined approach we've seen some institutions taking as well.
Awesome. Let's go to faculty next. So I think it's easy. Under CSA, generally they are not considered a CSA, except in what instances? There are some instances, right?
Yes, when they're an advisor to a club. So if a faculty member is an advisor to a club, or an advisor to a Greek organization or a club coach, they'd be considered a CSA. Or if an institution, and we know that some smaller institutions, there's a junior college that I teach at now, where faculty members are all considered CSAs, because it kind of has more of that high school environment where faculty members are very involved with students in their lives outside of the classroom. So you can deem faculty as campus security authorities, but typically they're not unless they are advising a club.
And one of the reasons I wanted you to talk about that was, I think what I'm also seeing on a vast majority of campuses is when they deem someone confidential, I'm seeing a large group of schools consider making affinity club advisors confidential. And here's why. When they go through and they look at the populations of their students who are on campus, and they start to kind of pinpoint what are some of the groups on campus that might be more vulnerable or more targeted. For instance, LGBTQ, folks who are undocumented, folks with disabilities, and we start to think about who has inroads into those communities on our campuses, and will those communities seek out the services that we have available to them on campus? And if you say no, if you did say an audit of your student populations and you realize that actually folks from this particular religious affiliation will not go to the counseling center, and that's the only confidential space we have. However, this particular group has a religious affiliated affinity club, and that particular professor, I have seen some schools make that professor a confidential employee, meaning that they don't have to provide any additional information to the Title IX office. They're exempted from Title IX reporting. So I wanted to bring up this one particular intersection in that you could have somebody who is a CSA because they're that affinity club advisor, but they can also be confidential under Title IX. And where they do not conflict is that the aggregate data that's required for Title IX purposes, so confidential reporters, when they're in that one bucket that makes them confidential, they have to provide aggregate data to the school, that CSAs also have the potential, and Allison, correct me if I'm wrong, they also could potentially, based on your policy, be allowed to provide non-personally identifying information. So there's a way that you can actually craft that person can be a CSA and a confidential employee, giving the correct aggregate data for Clery compliance purposes, and still be able to reach into a particular population or a particular group of students that could be really more vulnerable than others, and make sure there's that pocket.
And somebody said, I thought this was interesting, we tell CSAs if the disclosure or report originated with you, then you're responsible for notifying police if they're not already aware of the situation. And that's a great way too, because I know sometimes the chain of command reporting could get lost, and you certainly don't want that to happen through this process.
All right, should we go to academic counselor?
Sure.
So for a reason, go ahead, Allison.
No, I was going to say one of the questions I'm getting in here about the academic counselor is, what if they're a licensed therapist? You know, how does that fall into play? And I think that's something to take in place. When we talk about a licensed therapist, for Clery purposes, they have to be acting in that capacity. So, in another example, you might have a psychology professor who has a license and runs a private practice, but they're also an advisor to a club. So they're not acting, if this is disclosed to them, not in a counseling session, but as the advisor of a club, then that confidentiality doesn't hold, so to speak, or that privilege doesn't hold.
And that's the same thing for Title IX. The reason we put this in here is I have a lot of community colleges who the only kind of advising they have on campus is called an academic counselor. And many times those academic counselors, because they're dealing with a lot of different kind of life issues, right? Things that can happen with depression or circumstances that are happening outside of, you know, the classroom that are impacting their community college community. And they may have licensure within the state, but they've been hired to provide academic counseling, which is not the same as what their licensure is. So I think it's an important kind of distinction in talking about this in the capacity discussion. So for Title IX, in order to be considered, you know, privileged, which they would be if they were providing, you know, mental health therapy or whatever they're licensed to do. In this instance, for a lot of community colleges, they're not. They're actually providing academic counseling, which is not the same. So it was just a way to kind of bring up the distinction about the capacity, and it's the same as Clery in the sense that you have to be acting under your licensure or under your state law.
And I do want to add, somebody brought up, and Lindy brought it up earlier, voluntary confidential reporting. Under Clery, you have to disclose in your annual security report whether or not you have a voluntary confidential reporting process. And that means your privileged people, the folks who are licensed and acting in that capacity, may share the aggregate data, and it's voluntary and confidential. So they tell students, I can share this to be included in the numbers, but it's up to you, it's voluntary, and nothing else will be shared except for a number. So somebody kind of marked that, and that's just for you to determine, and based on the relationship you have with your counseling department, whether or not you're going to run that type of process.
And then lastly is the coach. For Title IX purposes, absolutely is going to be likely a responsible employee and would be required to provide information to the Title IX office or kind of the immediate supervisor.
And the same thing with Clery. A coach is a campus security authority, and there have been some cases, and they're all public through the Clery reports from the Department of Education. Often when there are challenges with campus security authorities, it can be when coaches are involved. So it's just so important to get your coaches in on trainings and have them understand what their obligations are, because often they'll have that rapport and relationship with students when they're on buses or in other types of situations where something may be disclosed to them.
We wanted to add another layer here and talk about another instance that's been coming up a lot in trainings and questions, is to let's make this into a dating or intimate partner violence story. So we're going to go back, we're going to add two different folks. We have Mary, who's introduced to Kevin at a party. They are dating for over a year. The first 6 months, everything seems to be going really well. Then Kevin becomes abusive, first emotionally, then physically, and then sexually. He's always nice around other people, but he tells her if she ever reports what he's done, he's going to know. She understands this to mean that she's in physical danger if she tells anyone else. After a particularly bad fight, Mary tells her RA about what happened and asks her not to tell anyone. So we have a different situation here, and I think we'll just stick with the RA since we've kind of gone through all the other different roles and what they do. But I do think it's something that we should talk about in terms of timely warning, and I'm happy to kind of, you know, get folks' thoughts on she's asking for confidentiality and whether or not that could be honored under Title IX.
And if you don't have RAs on your campus, just plug in someone into that RA box who would be a responsible employee in CSA. So in terms of timely warning, if you wanted to type into that box what you think you would do in this situation. Okay, timely warning would not be released. No timely warning. RA is required to notify the Title IX office. No timely warning. Tell student they'll keep it confidential, that she can't keep it confidential report. No timely warning. Not a security issue for campus, just Mary. And I think that's a good piece. It's actually something, I was a negotiator for the Violence Against Women Act amendments to Clery. And so they've kept us all in the loop as they're putting together the handbook. And this is kind of my one piece that I've really harped on for the handbook is domestic violence, dating violence, and stalking. We know some of the most dangerous times are when someone leaves. So certainly this is a dangerous situation, but a lot of you pointed out it's likely most dangerous for Mary. So releasing a timely warning or anything that can indicate to Kevin that she told someone may put her in more danger. And I mean, many of you kind of identified this at this point. Actually, I don't see anyone who said they would issue a warning. In terms of Title IX office, that's coming up, Lindy. A lot of folks are saying tell the Title IX office, so I don't know how you want to address that.
I agree. I think that at this point, you know, if it's an RA or someone who's in a responsible employee, absolutely they should alert the Title IX office. And I think since Mary is asking for confidentiality, I would hope that the Title IX office would also kind of look at the real lethality factors here in a dating violence situation and ensure that, you know, if they felt they had to proceed on an investigation, they could look beyond those factors that we talked about. And I think the most important thing, especially in intimate partner violence and stalking, is that we look at the risk to the individual. Obviously, you can always look at the risk to the campus. I mean, and that's obviously one of your biggest priorities. But at the same time, I think in these intimate partner and stalking cases, I think risk to the individual victim is incredibly high. And it sounds like you all kind of understand that dynamic, so that's awesome.
And so one of the things I wanted to ask kind of in closing, things to consider, and I think we talked about it, and every time I've seen Lindy talk, she really shares some great resources about OnePagers. It's now required under VAWA amendments to Clery to have kind of one-page information of all of your resources for students and employees who are reporting. So make sure you're promoting what the resources are and how to report, that you're sharing information between departments, and that you're training your campus security authorities and your responsible employees. And then I will add again in our notes section, in our handout section, there is something on the Springfield College training that I'll just pitch to Lindy over to talk about, because I think Lindy and Jeremy, who are co-presenting, do a great job of really kind of going back on what to do with investigations. So Lindy, I don't know if you want to take it from here.
Just quickly, we're going to be doing a 2-day conference at Springfield College. We are starting kind of soup to nuts. We're going to go from the trauma-informed lens through policy, confidential reporting, and then Jeremy's going to take over. We're going to have an agenda around what happens at the initial meeting, how to write a good report, investigations involving alcohol, and we're going to do appeals, sanctions, and deliberations as well. We're really trying to go from kind of start to finish, and we're hoping to be very pragmatic and give you really practical, tangible pieces. So if you guys are available November 2nd and 3rd, we'd love to have you.
And then I will add, too, we're doing a one-day conference down in D.C. on November 13th, Friday the 13th, at the museum to look at the past, present, and future of the Clery Act, since it's the 25th anniversary. So we're closing with a policy panel that's going to have representation from IACLEA, NASPA, ASCA, and the Clery Center. We're going to also go throughout the day and talk about certain things like safety planning. Lindy is going to present on that. We're going to have some other conversations focused around leadership. We have some college presidents talking about the role of leadership, so I encourage you to join us there if you can. I want to thank again Lindy for joining us, and for all of you for joining us today. You'll see a link in the chat panel for evaluation for today's webinar. We always appreciate it if you can give us your thoughts and feedback. If it was too much, if it was too little, where you need more information, because I think there's a whole slew of nonprofits in this field who want to help. And I know that Lindy's organization, VRLC, and the Clery Center, we love to collaborate with those groups. So the more we can do, the better. It's just one of several webinars that we did for National Campus Safety Awareness Month. You will get this recording in your email blast, but it will also be available on our YouTube page. You can click on the links in the chat panel to register for upcoming webinars, and if you want to receive any more professional development information, and then certainly follow VRLC and Clery Center on Facebook and Twitter for updated information and news stories. If you want to learn about other training opportunities, as we said in the link, you have the Springfield College opportunity, and then also the Clery Center does trainings throughout the country, and it's recently been updated and is more interactive through clicker technology to really take you through 2 days of diving into the Clery Act and kind of evaluating what you need to do. Lastly, throughout the month of September, if you're interested in joining our collaborative program, there's a 10% discount off of the membership, so all NACSAM participants are able to participate or to join for that if they have interest. And so we have our link up there, info@clerycenter.org, if you have any questions. As I will say, the Springfield College training is there, the 25-year anniversary info is there. And again, that changing our campus from the Office on Violence Against Women, Department of Justice, has the campus safety planning resources and other resources that are available for you. But I want to, again, thank you all very much for joining us, and thank Lindy again.
All right, thanks, guys.